Welcome back to Pace Immigration, paceimmigration.com, talking once again with U.S. and Canadian immigration lawyer Michael O'Rourke. Michael, good to see you.
Hey, Sean, how's it going?
Great. Always good to talk to you. Today, talking about a serious discussion, actually. It's can you get into the U.S. With a drunk driving conviction? We're going to use the U.S. vernacular of DUI throughout this presentation, but it's called many things from around the world. But if you have a drunk driving conviction in your past, can you get into the United States? You broke it down for me into kind of two criteria to look at: criminal and medical inadmissibility. Talk a little bit about this before we dive in deep.
Sure. So, inadmissibility in general is your inability to come into the United States for whatever reason. Substance use, drinking, drunk driving convictions, they can be looked at in two different ways. There are laws stating that certain people are criminally inadmissible for having been convicted of certain crimes. And then there are laws dealing with medical inadmissibility where the U.S. government seeks to protect the population against somebody who could cause harm. So it's a slightly different way of looking at it. But when we look at the U.S., we always have to consider both criminal and medical issues surrounding drinking and or substance use.
Okay, so let's take the first one first, which is the criminal inadmissibility. You have here a single conviction for DUI does not necessarily make a person criminally inadmissible to the United States. However, and we'll skip to the next slide, if the DUI charge was combined with other misdemeanor or felony offenses, it's big trouble, yeah?
Yes, that's true. So theoretically, a single DUI or DWAI, or depending on how your state categorizes impaired driving, a single charge that is resulting in a conviction will not necessarily make you inadmissible criminally. So there is a big however at the end of the last slide.
Right.
If there are two or more DUI convictions, then you are inadmissible and you will require a waiver. If there is a DUI conviction and there were other charges at the same time, so for instance, like destruction of property, or if there was an injury related or even a death related to your DUI instance, then that could potentially make you inadmissible. It's, as my favorite thing to say, it always depends on the facts. We always have to look at the facts, and if you appear at the border, your CBP officer may or may not want to get into the nuances of the facts. They might see either a felony conviction or multiple convictions on your criminal record. That will most likely result in you being turned away and requiring an entry waiver.
Right. Let's go back to that initial slide here with the single conviction. People should or should not take this to mean that if you have a single conviction for DUI on your record, just go ahead and show up at the border. There'll be no problem.
Yes. I think that if you have a DUI conviction, it always makes sense to talk to me or one of my colleagues about this, to really get into the facts and to just get an opinion if we think that you should preemptively apply for a waiver or whether you should take your chances. If it is just a single misdemeanor level DUI one time, especially if it happened more than 5 years ago, then I would say, okay, try it. But be aware that you could be turned away. If it is very recent, or if there's multiple misdemeanor and or felony convictions in your past, or multiple DUIs, then I would almost always say to apply for a waiver in advance, because you're most likely going to be turned away.
Right. I would say it's worth a phone call either way, right? Like
Exactly.
even if it's in a single DUI 10 years ago, because we've had stories, right, of people trying to get across the border going in either direction. I know we'll cover Canada another time, getting into Canada, but you can get surprised at the border depending on who you run into. At the
Yes,
yeah.
certain officers like to protect America more than others. I don't. I'm being. I'm
I
very much
understand. Yeah.
joking right now, but certain officers will take it more seriously, and certain officers will question you more than others. You also have to realize that U.S. CBP and their colleagues on the Canadian side of the border, CBSA, they have access to very detailed databases regarding past convictions, arrests. It goes beyond FBI and CPIC records. So if you think that you might be able to slip through with having had some sort of arrest and or conviction, they're probably going to see it.
Right. Okay. Let's carry on to medical inadmissibility, which I was kind of surprised is actually much more far reaching into your life than just even the criminal stuff. We've got here medical inadmissibility. When applying for a U.S. visa, alcohol related offenses are often reviewed under medical inadmissibility. And you've got here consular officers are required to refer a visa applicant to a civil surgeon for an immigration medical exam and if you wouldn't mind, Michael, go into some of this stuff.
Sure. So if you have to apply for a visa, that means generally anybody except for a Bermudian or a Canadian, then if you're applying for a visa and there is a record of DUI in your criminal records, the consular officer is required to refer you to an immigration medical exam if there is an alcohol related arrest or conviction within 5 years, if there are multiple alcohol related arrests, or if there is evidence of an alcohol addiction or problem. Depending on what you might put down in your DS-160, which is the universal visa application, or what criminal records the consulate has access to, they might be required to send you out to a panel physician. So if that happens, you've already waited so long for a visa appointment. This is going to probably add another 6 to 8 months to the process because you have to actually talk with or make an appointment and talk with the panel physician. They have to perform their exam, write a report, then that report is sent back to the consulate, and then the consulate must send it to the admissibility review office to make a final determination as to whether you can actually be issued a visa. So that's the process if you require a visa. If you are a Canadian or a Bermudian and you're coming to CBP to enter the country, and they can either find in your criminal records that you have had a recent arrest or multiple arrests for either alcohol or drug offenses. And the drug offenses we should talk about in a separate video because that's its own universe. But if you have multiple arrests or convictions, then they can also find that you could be medically inadmissible.
That's interesting. So the Canadian and Bermudian side is a little bit more lenient in the sense that you can do that, show up, you might have a single conviction somewhere in your far past or something, and you might get away with it. But if you're not from a visa-free country and you have to apply for a visa, this is going to pop up, and then you're going before the immigration medical exam.
Exactly.
Okay. Let's dive a little deeper into it. And this is what I meant by the medical side of the DUI, which I don't think a lot of people even really know about, reaches far into your life. It's got here, a substance-related disorder does not by itself make an applicant ineligible for a U.S. visa. But Michael, I know you wanted to go deeper into that.
Yeah, let me give you an example of an interesting case I had a few years ago. So there was a Brazilian couple, and one of them worked for Microsoft, and the spouse had a grinder in a bag in their luggage, and when they came up to Vancouver for the weekend. They had fun. They didn't necessarily use the grinder or anything else, but when they were returning to the U.S., a search of their belongings revealed this grinder in a makeup bag. And the CBP officer at that moment canceled the visa and said, "You must return to the consulate and get another visa." 6-9 months later, she was able to get an appointment finally at the U.S. consulate in Vancouver. She could not return to the U.S. With her husband, and then she was sent to a panel physician to determine whether having that grinder in her makeup bag was actually the sign, or was this an indication that she had a substance abuse disorder. It wasn't criminal. It was, is she addicted to the use of marijuana or other substances that could be ground? I'm such a nerd. I don't know what you would grind other than that, but I'm sure there are things. Anyway, the panel physician made a report. We had to supply affidavits from everybody and her mother, literally her mother, to say that no, this was a medically prescribed thing in Brazil, that she had the equivalent of a medical marijuana card there, and that she did not have an addiction to cannabis or marijuana. Finally, they issued a visa to her and she was able to return to the US, but it took probably about 14-15 months before the whole process was completed. So what they were looking for was, did she have an addiction? Was she a threat to herself because of this addiction, or could she be a threat to others in the United States if she were allowed to come back in?
That's interesting. It's funny how they look at certain things. I mean, you go to the duty free, you bring back 2 bottles of vodka, and they don't blink. But if there's something in your far past, they could say, well, maybe you're addicted to booze. It's
exactly.
Yeah, it's an interesting way that they look at it. This one down here at the bottom, you've got we've got the threat to yourself or others. That is a judgment call that they're making on the medical side, I guess, that they're saying, okay, you might be a regular everyday person, but this stuff in your past shows that you have the propensity to hurt yourself or others.
Exactly. There's a U.S. case called Matter of Harenka, which has a balancing test to determine whether somebody is going to be a threat to the people of the United States if they're allowed into the United States. So this is a short way to say, would you harm yourself because of this addiction, or could you be considered harmful or a threat to U.S. citizens if you're allowed into the United States? For instance, if you have a heroin habit, for instance, and to support your habit, you have to rob convenience stores. I'm making up the preposterous example, but that could potentially be considered as being a threat to others because you have this overwhelming addiction that you cannot otherwise contain.
And all of this can stem from a couple of DUI convictions going down this road.
Yeah, or less, honestly.
Right, which is why I think it does behoove people. I mean, they need to give you a call. This isn't a sales pitch. It's just common sense that they need to talk to a professional before going down this road on their own and exposing themselves to the system and just seeing what happens. You know what I mean?
Yeah, exactly. It's everybody tends to understand criminal inadmissibility. It's like, okay, I got a DWAI conviction in New York State 30 years ago. I understand that this is a warning in the United States, but they don't understand that. I'm sorry, I actually mixed up my example. I got a DUI conviction in Canada 30 years ago, and I understand what that means in Canada, but I don't necessarily understand what it means in the US, other than it's probably a crime too. But the whole medical inadmissibility side of things actually adds another gloss to it, and it's unpredictable almost how it's going to be viewed. So it is always worth talking to a lawyer, just if you have this in your past and you're worried about it and you don't want an unpleasant experience with CBP. And often they are unpleasant if this is something that is in the background.
Absolutely. And I don't blame you for mixing up some examples, because we have another video coming out talking about Canada and getting into Canada. There are some slight differences between how that works and the United States. So we'll get into that another time. Michael, thanks for taking the time with us. It's Michael O'Rourke at pacelawfirm.com. M. O'Rourke at pacelawfirm.com is the address. Michael, the first thing you want to see in an email that somebody sends to you, what do you want to see?
I want to see what has happened. I want their best recollection of the facts around it, because these things always turn on the facts. It's my favorite lines. Like, well, it depends. You might be inadmissible, you might not be inadmissible, but when we start looking at this, we really need to know what happened, because a conviction, even if the person knows what statute they were convicted under, doesn't give us all of the information. So facts are key.
Okay. Thanks, Michael. We'll cover the Canadian version soon, and we'll talk to you again then.
Sounds great, Sean. Take care.
Bye-bye.
Bye-bye.